Welcome to The Explainer. Today, we're demystifying the rulebook for all civil disputes in India.
So let's start with a fundamental question. How does our justice system take a really messy human conflict and navigate it toward a clear resolution? It's not just about what you see in movies.
All right, here's our roadmap for this journey. We're going to look at the rulebook, how a lawsuit even starts, then dive into the paper battle, see how the court actually decides, and finally, what happens after the verdict.
So first things first, let's talk about the rulebook itself. What exactly is this civil procedure code, or as lawyers call it, the CPC?
Okay, think of the CPC as the operating system for the entire civil justice system. It's like a GPS that gives everyone, the plaintiff, the defendant, the lawyers, the judge, the exact same map to follow. It's all about making sure everyone plays by the same rules.
Now, let's move to a hypothetical case. Let's say A lent some money to B, but now B is refusing to pay it back. So how does A actually start the legal process? Well, there are three absolutely crucial first steps, and you have to get these right or the case can stall before it even begins. First, you choose the right court, then you file your plaint, and finally, you have to serve a summons to the other party. And this is a brilliant illustration of how jurisdiction works. The law actually gives you options. You can sue where the defendant lives, in this case Delhi, or where the actual incident happened, in Calcutta. It makes a lot of practical sense.
Now, a summons isn't just a polite invitation to court. No, it's a critical legal document. It's a formal order that officially brings the defendant into the lawsuit, telling them exactly when and where to show up.
Once the defendant has been notified, the case moves into what's often called the paper battle. This is where both parties lay out all their arguments in these very formal documents that are called pleadings.
The plaintiff is basically the first shot fired in this paper battle. It's where the plaintiff lays out their entire side of the story for the court to see.
And then the defendant fires right back with something called the written statement. This is their formal defense, their side of the story.
And what's really fascinating here is how these two documents are perfect mirror images of each other. The plaint starts the fight. The written statement responds. The plaint makes the claim. The written statement admits or denies it. It's this perfect back and forth.
But get this, the defendant can also go on the offensive with something called a counterclaim. This is where they essentially sue the plaintiff back within the very same case. It's like a lawsuit within a lawsuit.
So after all the paperwork is filed, the court finally hears the arguments and looks at the evidence. And all of this eventually leads to the final decision.
Now, here's a crucial point. The court's decision actually comes in two parts. The judgment is the why. It's the judge's reasoning. And the decree is the what. It's the final legally binding order. This whole process is guided by a fundamental legal principle. It's a Latin phrase, actus curia niminem gravabat. And what it means is that an act of the court should harm no one. It's a powerful reminder that the goal here is always justice. But what happens after that decree is issued? Believe it or not, the journey often continues. Now you're either enforcing the win or, well, challenging the loss. So yeah, the verdict is really just a milestone, not always the final destination. You've got three main paths forward from here. You can enforce the decision, you can challenge it in a higher court, or you can take what's called an off-ramp and try to find a settlement.
To make sure a win is actually a win, the court has some pretty powerful tools at its disposal. It can seize property, force a sale, and in some serious cases, even order an arrest to make sure its decree is followed. And this brings us to that off-ramp I mentioned, alternative dispute resolution, or ADR. This is the legal system's way of encouraging people to find a faster, less expensive solution outside of a formal, full-blown trial. And the options here are really diverse. You've got everything from formal arbitration to more collaborative things like mediation, and even community-based courts called local adalats.
So to sum it all up, the whole point of the Civil Procedure Code is to bring order to the chaos of a dispute. It's all about making sure conflicts are handled with fairness and, just as importantly, with consistency.
And that leaves us with one final thought. While all these rules and procedures are absolutely essential for being fair, we have to constantly ask ourselves, are they actually helping us get to the ultimate goal, which is timely justice for everyone?